Who has the right to file a tax grievance, especially under net lease? To find out, you have to read DCH Auto versus Mamaroneck. It's only 14 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. The episode on the case of DCH Auto versus Town of Mamaroneck, which is in Westchester County. This can be found in 2022 New York Slip Opinion 03929, published by the Court of Appeals on June 16th, 2022. This is a civil case, a real estate law case. The issue in this case is, may a net lessee file a grievance on the tax assessment under Real Property Tax Law 524 sub 3, and I'll explain all this in a minute. The law you have to understand this case is that there are leases, which are when a person rents property, and then there are net leases, when a person rents not only property, but agrees to pay the underlying real estate taxes as well. Additionally, you have to understand that there's a two-step process when a party wants to grieve or complain that a tax assessment is inappropriate or improper. The process is, and there's two statutes that apply, it's Real Property Tax Law, which is RPTL. I'm going to say RPTL from now on. RPTL 524, which is step 1, and RPTL 704, which is step 2. The first step of a grievance process is a complainant who is dissatisfied with the property tax assessment can file a grievance or complaint with an assessor or a board of assessors. It requires, though, that the complaint be filed by the person whose property is assessed. That's the language. By the person whose property is assessed, or an agent of theirs, but that's not relevant to this particular case. And the second step in the process, so once a person files a grievance with the board can either approve it and change the tax assessment or deny it. If it's denied, step 2 of the process is RPTL 704, in which a person then claimed to be aggrieved by the assessment can petition for judicial review, can go to court and file a petition for review of the assessment decision by the board. As part of that, a condition precedent to the filing of that petition is that a proper complaint was filed under RPTL 524. And that second step can be done by any person claimed to be aggrieved. So any person claimed to be aggrieved can file the RPTL 704 petition. Okay, that's the law here. So the facts in this case are DCH Auto has a net lease, right? So they've agreed to pay the rent and the taxes for 20 years from the owner. And in the agreement, the net lease agreement, they also have a provision that they're allowed to challenge the tax assessment. Now, DCH files an RPTL 524 complaint. That's step 1. Challenging 8 tax assessments. Goes to the board of tax assessors. They don't dismiss it. They don't give them any problem. They actually deny it. They say, nope, we've considered it and we deny it on the merits. So then DCH goes to step 2, RPTL 704, and petitions for judicial review of the denial. At that point, the town and the village of Mamaroneck, the respondents here, move to dismiss and say, wait a second, you're not the owner. You are not properly the person that can bring an RPTL 524 grievance. And therefore, you have not satisfied the condition precedent to bringing the RPTL 704, the step 2 process. So the trial court agrees, the appellate division affirms, and it goes to the Court of Appeals, and they reverse. That's this case. The Court of Appeals identifies that the issue here is the language here that a person whose property is assessed, does that mean owner, or does it also mean net lessee? And is the person whose property is assessed, is that different than the person claiming to be aggrieved? Because those are the standards under RPTL 704 and 524. They go through the history of the statutes underlying and preceding RPTL 524. They talk about how in 1799, they go back and do the history lesson here. In 1799, the language was any person conceiving himself aggrieved. In 1851, it was any person conceiving himself aggrieved, which, by the way, is the same language, essentially, as RPTL 704, any person claiming to be aggrieved. In 1896, the language was changed from any person conceiving himself aggrieved to a person whose property is assessed. But at that time, the New York State Commission on Statutory Revision said there's no substantive change here. So looking at that, the Court of Appeals says they're the same thing. There's no difference here. So the holding is a net lessee satisfies the person whose property is assessed under RPTL 524.3. And they also note that this makes sense, that it should authorize a person to do step 1 and step 2. The same person should be allowed to pursue both steps. It shouldn't be that the owner is required for step 1, but at step 2, a net lessee can pursue that grievance. And so that's the holding. Too long, didn't read. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.